Hello and welcome to another program in the 10-Minute Tip series, a series of programs for credit professionals. This one is entitled Non-Disclosure Agreements and Confidentiality Agreements. My name is Michael Dennis and I will be your presenter today. Let's begin with an introduction. NDAs, or confidentiality agreements, are all about the idea that we need to keep secrets secret. No supplier wants a customer to steal or use confidential information, and no customer wants a supplier to steal or use their confidential information. Why? Because great ideas deserve protection. It's my position that an NDA, or confidentiality agreement, may not be the only document, the only agreement that you need with a customer, but it's a great start. The goal, the intent of an NDA or a confidentiality agreement is to limit the risk of unauthorized disclosure of confidential information. Important information about non-disclosure agreements. Any NDA that you sign will need to address in some meaningful way these issues. What type of information is going to be shared? How specifically will the information that's being shared pursuant to the non-disclosure agreement be used by the recipient? How long will the secrets need to be kept by the recipient of the confidential information? As it relates to the recipient, who specifically is entitled to see that confidential information, and equally important, who is not permitted to see the information? Let me elaborate on that briefly. Let's assume that you sign a non-disclosure agreement with a customer, and in return the customer provides you with a copy of their financial statements. With this scenario in mind, it's important to understand who may and may not view that confidential information, those financial statements. Generally speaking, if I were the customer, one of the things I would say is the credit department can use it for the purpose of evaluating our company for credit, and that's it. You can't share it with a salesperson. You can't share it with your industry credit group. You can't share it with a credit reporting agency. You can't share it outside of the credit department. And probably that's a reasonable and a realistic expectation about who will be entitled to see the confidential information. Another important piece of information in the NDA relates to what must the recipient company do in order to safeguard the confidential disclosures. What steps do we need to take? How do we safeguard them? Where do we put them? Are they required to be locked up? What steps in particular are we expected to take to safeguard the confidential information? And ultimately, will the information be returned? If so, how? If not, what do we do at the end of the non-disclosure agreement period with the confidential information? Do we destroy it? Basically, the options are destroy or return. Employee NDAs. Sometimes a company will require a newly hired employee to sign or execute a non-disclosure agreement. If that's happened to you, you know exactly what I'm talking about. If it hasn't happened to you at some point in your career, it probably is going to happen. The key language in an employee NDA revolves around the idea that the employee will state or agree that they will not disclose any confidential information that they learn as an employee of the company to any third party. They won't reveal it now, and in all likelihood there'll be an expectation or requirement that they won't reveal confidential information even after they leave employment, even after they quit, even after they resign, even after they retire. The purpose, the intent of an employee NDA is to restrict the employee's use of company-owned information, specifically the company-owned information which is deemed by the company to be confidential, proprietary, or even a trade secret. In addition to signing one time, basically when you join the company, it is possible, depending on the job that you do in the organization, that you'll be asked to sign additional non-disclosure agreements. These often come in connection with a new business opportunity. Largely, these additional requests for non-disclosure agreements in connection with an existing employee relate to a request by a customer. In other words, the customer says, I'm willing to share this information. It's highly confidential. I want everybody that touches my information to sign a new non-disclosure agreement that I get a copy of, even if they've already signed a non-disclosure agreement with your company as their employer. What these additional NDAs do, if we didn't need a reminder already, is they serve as a reminder to the employee signing it, of their obligation to keep secrets secret. Scope of the NDA, that's something else that we need to worry about. Each party to an NDA, and typically there are two parties. These are mutual NDAs in which each party's confidential information is protected in some way. Each party to an NDA wants to understand the scope of the non-disclosure agreement so that both parties know what type of information is covered by the non-disclosure agreement, what type of information is not covered by the non-disclosure agreement. Not surprisingly, there's often a dispute between two parties interested perhaps in signing an NDA about what is to be considered confidential information. For example, one party may want to limit the scope of the non-disclosure agreement. In other words, they may want to limit what is considered to be confidential. For example, they might say, only documents that are conspicuously marked as confidential should be considered confidential and covered by the non-disclosure agreement. If you forget to mark something as confidential, it's not confidential. If you say something to us, no matter how confidential that discussion might be, verbal disclosures cannot be considered to be confidential. On the other hand, another party, and this often happens too in the context of NDA negotiations, is that one party may want to add language that suggests something like everything that we discuss and every piece of information that we share with each other, no matter what the form, writing, text, email, you view it, you hear about it, we talk about it, everything is considered to be confidential. And then at some point, eventually, the parties will agree on the scope. They'll agree about what is and what is not to be considered confidential and therefore covered by the terms of the non-disclosure agreement. I want to talk for a minute about verbal disclosures. So, one party or both parties may want the non-disclosure or confidentiality agreement to cover verbal disclosures. And the other party may be opposed to that idea. They may reject it. They may say, nope, only things in writing can be covered by the non-disclosure agreement. In my opinion, it's a mistake to limit confidential information to written documents. Why? How come? Why is that a problem? Well, from my perspective, it's not the way business typically operates. Why? Because employees working for your company and employees working for the other company at some point are going to talk to each other. And when they speak to each other, not surprisingly, they're likely to talk about things that one party or both would consider to be confidential. Therefore, not all confidential disclosures are going to be in writing. And I would argue that probably most of the confidential disclosures occur face-to-face. They occur in person. They don't occur in writing. They may occur by email. They may occur on the phone. They may occur face-to-face. But in writing is a subset of the total amount of information and data that's being exchanged between two parties that are interested in doing business with each other or are doing business with each other today. And therefore, again, my opinion is this. The non-disclosure agreement or the confidentiality agreement should include protection for verbal disclosures. Exceptions. In the NDA, there should be an exception clause, and these are the things that we would expect to see as being exceptions to the confidentiality obligations. Information that you knew before you signed the non-disclosure agreement generally would not be considered confidential. Confidential information that you receive from a third party generally should not be treated as being confidential. So if you don't receive confidential information from the other party of the NDA, but you receive it from a third party, let's just say for convenience, the third party is Dun & Bradstreet. Clearly, the information that you obtain from Dun & Bradstreet should not be governed by a confidentiality agreement that you have with a customer, even if the Dun & Bradstreet report is about the customer. In addition, independently developed information by one party should be excluded from the non-disclosure agreement. And of course, disclosures of confidential information that are made, let's just say, to the FBI, because that's topical today, disclosures of confidential information to the FBI pursuant to a court order would be an exception to the obligation of the party with the confidential information about not disclosing it to anybody else. Obviously, the companies need to obey the law even though they have signed a non-disclosure agreement. Expiration. It's important to remember that typically obligations under a non-disclosure agreement do not expire when the non-disclosure agreement expires. And I know that sounds weird, but that's true. And there's a very good reason for it. And that is that if, in fact, the obligations to protect confidential information expired when the NDA expired, then in theory, I could share information with you today. You could terminate or expire the document tomorrow, and you could start using my confidential information the day after tomorrow. So generally what NDAs and CAs have are two important dates. One is the expiration of the NDA. So typically an NDA might say, this non-disclosure agreement expires in, let's just say, a year. It expires 365 days from the date from the effective date, from the date of signature. The second date is sometimes called the tail. And what it means is it's the amount of time after the expiration of the NDA itself that confidential information needs to be safeguarded, needs to be protected by the recipient. So generally you'll find key language along these lines. Confidentiality obligations will extend for X years from the date of disclosure. And again, the tail, this X year period, applies even if the underlying contract, even if the NDA has been terminated or has expired. So what's reasonable? I don't know. I've seen NDAs with a tail of 10 years. Probably 3 to 5 years is what you normally expect to see. So basically what they say is this contract, this NDA, is going to be valid for a year. But no matter when it expires or is terminated, the obligations of confidentiality that are described in the non-disclosure agreement are valid for, let's just say, 5 years from the date on which the recipient received the confidential information from the other party, from the party disclosing the confidential information. Well, that's it for this 10-minute tips program. I hope you found it interesting and helpful. Thank you for your time.